Get on the train before it leaves the station. The truth train is coming, gonna run them down, run them down.
Alrighty, hello there folks, how you doing? Okay, the state has filed its response. It is upon us. Okay, so I've gone through about 3/4 of it. Sorry, worked late and couldn't get all the way, but I've picked out some of the interesting stuff here from, like I say, probably around the opening 3/4 of it. Picked out a few things to show. I'm going to do something more comprehensive probably on Sunday, around midday on Sunday, a bit more comprehensive, but just reading kind of through it for the first time, and picking out some things that I saw that were interesting, along with one thing that I noticed by AC Rookie that he pointed out over on Twitter. And so when I got to that part of the brief, I also went, oh, okay, yeah, let me go grab that the transcripts that AC had posted regarding that. So you guys will see what's coming up on that, but want to give AC his props on that. So, all right. So it's here. You can read it now. You can check it out. It's a lot of what you would expect, to be honest. Basically saying that Stephen Avery's claims are BS and blah blah blah. Procedural bar. They basically say ineffective assistance of counsel, of the post-conviction counsel, is basically. At one point, they argued that that argument is pointless because they basically say Zellner's argument is a losing argument, and that post-conviction counsel would have been insane or would have been ill-advised. They use proper wording, but they say something like it would have been ill-advised to back a losing strategy. Basically, is what the state basically said. Which is basically saying they believe what Zellner's come up with is crap in their own way. So there's that, and then a lot about the fact that Avery's new evidence isn't actually new evidence. It's actually just reanalyzing, for the most part, reanalyzing old pieces of evidence that existed previously. So it's actually known evidence, and it's this and that and whatever. So they get into arguing, that whole bit and that sort of stuff. So, but there's some points they make as they're going through that I thought were interesting, and I kind of pulled out as I was going through because, I thought I'd go ahead and talk a little bit about them. So, all right, I got a few clips selected out, and I'm going to go ahead and show you the first one now. It's basically from pretty much around the beginning of the brief, or the response, and so we'll come on back in a second. Alrighty, so this is from the state's response, and this is from early on here, page 15 and 130, as a matter of fact. So this is interesting because what they're saying here is quite interesting. So it says this court should affirm the circuit court. And then it says, was the circuit court required to allow Avery to pursue his section 97406 motion piecemeal for any of the following reasons? And number one, because the parties had reached an agreement about how Avery would proceed with scientific testing, which had been done. I'm sure Zellner very much regrets trusting Fallon at his word. Because Avery planned to supplement his motion but did not alert or seek approval to do so from the court because Fallon had told her that she didn't need to, that they would notify the court when they got the RAV4 down to Calumet and everything ready, then they would notify the court. But the court suddenly ruled very quickly, quicker than they ruled on any of the shorter supplements and motions that came after it. But anyway, so third thing, because the circuit court's 2007 preservation order, which I do believe Kathleen Zellner has mentioned. Anyway, the circuit court was presented only with the first two of these arguments. Excuse me? I'm pretty sure that argument about the 2007 preservation order was offered. Anyway, and noted that Avery never requested that the court withhold decision on his Section 97406 motion. Right, because Zellner, thought Fallon was, an honest guy, but he's not. Nor informed the court that he planned to supplement the motion until after a final ruling denying his claims. Oh, brother, the final ruling came within a day of the testing being arranged. Oh, like within a day or two of it. I mean, oh, geez. And like I said, 1,000-page motion, and the decision came quicker than any of the shorter motions and supplements that followed it. This court, okay, so sorry. Until or after a final ruling denying his claims. It determined that Avery could not amend a motion that was filed without reservation after he receives an adverse ruling. This court should affirm the circuit court. Did the circuit court erroneously exercise its discretion when it denied Avery's motion for reconsideration and multiple supplements to it without holding an evidentiary hearing? The circuit court noted that Avery mischaracterized as new evidence what were really new claims, and he did not set forth a sufficient reason why these many claims could not have been raised in a single Section 97406, nor did he give a sufficient reason for filing his June 2017 motion when he knew his investigation was incomplete and that he had planned on raising additional claims. It denied the claims raised in the motion and supplements as procedurally barred. So we're going to be going with the procedurally bar argument here on some of this. Well, that ought to be interesting. All right, so, okay, there obviously you have the bit where it's they're discussing whether or not there was an agreement for ongoing testing, which Zellner was arranging, I explained the circumstances of all that, what to see what happens with the appeals court in that, on a lot of these things, obviously, but, I just felt that was strange, and I do remember Zellner talking about the what's it called? The order by Judge Willis to preserve biological material and that sort of stuff. Anyway, so that was interesting. Then obviously you see again the reoccurring of the procedural bar comes up a lot. They are often talking about Stephen being procedurally barred from bringing his claims and this and that, and so it goes throughout this thing quite a bit. Okay, and I just want to show you this next bit. Because I feel, I'm not saying the state that what they're arguing here isn't backed up by law, but what I would point out here is that Stephen is kind of a unique case in a sense. Not a lot of pro se prisoners have to deal with a case file the size of Stephen's, to the point where he wasn't even able to have his entire case file with him in his cell at all times. He had to kind of pick boxes and bring them in and take some back to the place where it was all stored, because it's such a large file, and so that's what Stephen would have been dealing with. Obviously, with Stephen's limitations, he didn't have the highest IQ himself. He has, he's not a lawyer and everything. So, I mean, and I appreciate. I'm not saying that, like I said, I'm not saying that the state, what they're saying in this next bit isn't backed up by law. But I think with Stephen's case, there has to be some amount of, this is a bit of a unique situation. Anyway, we'll see you in a minute. Okay, so this is interesting, folks. So this right here is they're talking about, basically the state's arguing why all of the things that Stephen and Zellner brought in the 2017 97406 motion, they're arguing basically that all of those things could have been brought previously in Stephen's pro se 97406 motion back in 2013. So what they're saying is because they're basically making the argument that because Stephen himself didn't raise these issues in 2013, they're procedurally barred. Now, the thing is that Stephen has argued in his motion that he was a learning disabled indigent prisoner. And so therefore, he has a great deal more trouble understanding and picking, and getting the factual basis correct and all those sort of things. He's just not really very well equipped to do that, right? And so that was the argument. And the state is sitting here basically right now saying it's a BS argument, and I disagree. I disagree that it's a BS argument, because seriously, if Stephen Avery is not a lawyer, and he's not a scholar, he's not. He was an indigent prisoner, and not a lawyer. So how they expect Stephen to be able to be able to do all the things that they're suggesting he should have been able to do. And basically, let me just show you something here. This is their reason why that Stephen's reason doesn't matter. You see that, folks? Ignorance of the law is no defense. That's what the state's going to claim here. Now, I know that ignorance of, for instance, if you go out and you're driving in your car and you don't wear your seatbelt and you get pulled over and the cop is going to write you a ticket, okay? They'll write you a ticket, and because you didn't have your seatbelt on. And if you say, well, I didn't know I was supposed to have my seatbelt on, they're going to say, well, ignorance isn't an excuse. Well, that's fine when you're talking about one little thing, but when you're talking about constructing an entire legal motion and all those sort of things, and you expect Stephen Avery to be able to, you expected Stephen Avery to be able to do this in 2013 when he can't even have all of his case files in his own cell at the same time? This argument, it just seems to me just very, very cold, callous, and just not very it just seems very, very tacky, honestly. Anyway, so Avery's allegation was insufficient for a second reason. While a lack of knowledge of the factual basis for a claim may be a sufficient reason, it has long been recognized that a defendant's pro se status or lack of legal knowledge is not. See State v. Jensen, and that's where it comes in, the ignorance of the law is no defense, right? Okay. Nearly all collateral attacks are raised by pro se prisoners, many of whom have intellectual challenges and very few of whom have lawyers. While the Wisconsin courts liberally construe pro se prisoners' filings, prisoners are still expected to properly raise claims for relief, including sufficiently overcoming the procedural bar. So again, back to the procedural bar. That's basically all they're going to say here. Well, so far, 26 pages in, and that's basically all they've had to say so far, is Stephen is procedurally barred. Procedural bar, procedural bar. Hope they didn't use that argument for the bones, because, well, actually, I do hope they use that argument for the bones, because I already know that the Court of Appeals wasn't very charmed by their procedural bar argument regarding the bones. So, but I just wanted to point that out, that they basically expect Stephen Avery in prison, a guy whose case file is so large he can't even keep it, he can't even have it all with him, when most prisoners, if you guys remember when I talked to Ricky Kidd, most prisoners are able to have their entire case file. So it's probably certainly a lot easier for a lot of those prisoners to raise their claims, because they don't have the same problem Stephen has, where his case record, the file, of his case is so large that he can't even have all of it at one time in his cell. These are issues. Obviously the state is just going to casually disregard these issues, but to me, this is a huge problem. Stephen is not really like other prisoners. Most prisoners don't have a case file as large as Stephen's. And you expect Stephen to be able to go through all of that material and argue it like a lawyer? Like a pro? Look, the law is the law, and they may be stating something that's actually recognized by the courts, but I hope the appeals court is going to, look a little deeper than that. Okay, so I hope the appeals court uses a little more consideration about that there. I mean, gotta understand Stephen's in a unique situation with the fact that his case file is so large. And, so anyways, and you gotta kind of recognize the fact that when you're a prisoner in prison, you can't really kind of do all the things that somebody who isn't in prison can do. So, I mean, there's some of that too. I mean, but anyways, moving on. Next thing we're going to get into is they got into talking about Denny. They got into talking about Ryan and talking about Denny. And I had a few things to say about Denny, so I went ahead and included this part. So, here we go. Alright, this is an interesting little bit here that refers to Denny, and so I'm going to go ahead and have a few things to say. So, nor would Avery's non-existent facts be enough to prevail on a Denny motion alleging Ryan Hillegas was a possible third-party suspect. Nothing he alleged in his motion established jealousy as a motive. You see, because that's the one thing that Judge Willis required. He didn't. He required that they had to have motive, opportunity, and means. So they had to have means, motive, and opportunity, right? Well, Strang and Buting were able to determine that Ryan had too, but they couldn't establish a motive clearly for Ryan. So therefore, Judge Willis wouldn't allow them he wouldn't allow them to include Ryan as a Denny suspect, right? But here's the whole interesting thing about it is if the prosecution is arguing that this crime had no motive, you understand, why would the third-party suspects need to have motive? If the prosecution and the state are arguing this as a motiveless crime, in other words, it's an act of, it happens out of the blue, right? So it's not really out of motive. It's just their theory is Stephen picked Teresa that day, that it's that kind of a crime. Well, if it's that kind of a crime and there's other suspects, why would they need motive suddenly? Why is it if this crime is committed by Avery, it's motiveless crime, but if it isn't Avery, then those people had to have a motive for what the prosecution deems a motiveless crime. So I've always had an issue with that right there. It seemed odd to me that you're going to require from the defense a motive, but you're not going to require one from the prosecution. That just seems off to me. That doesn't seem right. Alright, so mainly my point there is I just feel it's disingenuous to require a motive from the defense if one isn't being offered by the prosecution. You see what I mean? I think that's disingenuous. I think that's not exactly equitable and fair. In my opinion, that is just not. Okay? Alright. Okay, this next bit was really funny, and I just ended up including it because it just made me laugh. Looking at what the state said here and what the state left out, I think is very, very interesting, and it just made me laugh. So I wanted to go ahead and share it with you guys. So here we go. Okay, so when I read this one, I kind of laughed. So, okay, here they go. Talking about the circuit court noted that Avery's argument about the result of this testing left out several significant facts. First, Reich had conceded that there is no forensic test available that can conclusively determine whether DNA was left by Sweat. As such, the report cannot conclusively state that the DNA on the hood latch could not have been left by Sweat of the defendant's hand. Furthermore, while 11 of the test subjects did not leave detectable DNA on the hood latch, the fact remains that 4 of the test subjects did leave detectable DNA on the hood latch. The circuit court concluded that, contrary to the defendant's assertions, the test of the DNA on the hood latch does not rule out the defendant's hand as a source of the DNA, and in fact, the report declines to make such a conclusion. The report makes a conclusion that the 4 people that did leave DNA on the hood latch left less than a tenth. I mean, it's insane. It's like 0.007 or 0.006. I mean, it's an insanely low number. Compared to the 1.9 nanograms that somehow Steven left, when only 4 out of 15 people were barely able to leave less than a gram, less than a nanogram. Let's just say that, less than a nanogram. 4 people managed to leave something, and it was all less than a nanogram. And somehow Steve miraculously left 1.9. They're leaving that out, and they're arguing that it's very disingenuous. But I thought I'd point that out because when I read this, it made me laugh. I'm like, you're gonna say that 0.06 or 0.07 is the same as 1.9? That's disingenuous, to say the least. Okay, so I just thought that was funny there. The state basically arguing that there's no importance in the discrepancy of the DNA. In fact, they don't even mention it. So, anyways, all right. So, okay, now we're gonna move into the last bit. This is the bit I was talking about earlier that I saw a tweet from AC Rookie on Twitter just before I started reading, and at that point, I had noticed what he had put there. I was like, oh, that's interesting. When I got to that part of the brief and I got to that part that he had posted, I was like, I went ahead and grabbed that part out of the brief, and then I went ahead and over to his Twitter, and got the part of the transcripts where there's somebody testifying about bullet, item FL, and what kind of matter was on it, right? So, anyways, here we go, and we'll come back one last time. None of the experts who testified at trial claimed that bullet fragment FL or FK was used in the fatal shots. What the state submitted about the 2 bullet fragments and 11 casings recovered from Avery's garage was ballistics expert Newhouse's opinion that all 11 casings and bullet fragment FL were fired from the .22 rifle. And yeah, right. Okay, so here's the thing, and I'm gonna, they're claiming that nobody was claiming that item FL went through Teresa's skull. Well, that's not true. All right, and I gotta give AC Rookie credit for this. Obviously, he snagged this, and I saw it on Twitter. So I wanted to go ahead and show everybody. So what it's saying is this guy is apparently referring to some material that he was given, some information, about a spent bullet recovered at the scene containing specimens of the decedent. Okay, and that would be indicative to me that the bullet had passed through the brain at a time, whether it was liquefied blood or that it wasn't going through specifically bone fragments. And it's like, what is this guy talking about? How do you get to the brain without going through skull fragments? I mean, obviously the prosecution is arguing about 2 beveled holes in the skull fragments where they're claiming bullets went through. You're claiming this is item FL they're talking about, and they're claiming, you see it right here, the bullet had passed through the brain, right? So clearly they did say at trial that they believed item FL passed through Teresa's brain. Now, they're trying to make some weird argument here about that it wasn't going through specifically bone, which I think is ridiculous, but regardless, here it is. Bullet had passed through the brain. Okay, so that's where I got to tonight. I'm going to wrap this one up as part 1 and get it uploaded and get some sleep and come at it with maybe part 2 and then more comprehensive live on Sunday. Perhaps I'll even get Mr. Texas 2 counties up in here as well. And so, that, it's, interesting enough, though, to see how the state's arguing. Now, I didn't get to the part about the bones yet, so that's obviously going to be in the next one. I know a lot of the other YouTubers out there are also commenting on this. I saw Millbilly did a live about it already. I think Foul Play already has something scheduled to go over it. So there's going to be a lot of commentary out there regarding it. So go ahead and check it out. I'll be back with more of my commentary, like you saw here, and we'll go through this thing, and we'll just go through it and go through it. Now, I know it's frustrating because you know it's all within the limits of the law and all within the framework of the law, and that's what makes some of this difficult and why it is so hard. And that's obviously what's getting argued, and that's always what's such a big deal about all these motions and filings and various things. So, all right, so that's about the first half of the state's response to Stephen Avery's motion to appeal. And like I said, we'll be back soon with a part 2 where I'll kind of cover the last half of it. Be looking for something special coming up here soon, folks. And if you haven't already, please hit subscribe, and we'll see you.